Mr. Rudolph? Good morning.
Good morning. Paul Rudolph on behalf of the appellant Pedro Saletino. With me is Nona Walker, who authored the appellate briefs in this case. I was trial counsel. 38 years ago, this court first recognized the defense of entrapment in the case of Commonwealth versus John Harvard. And in doing so, this court said the following: what the state cannot tolerate is having its officers instigate crime by implanting criminal ideas in innocent minds, thereby bringing about offenses that otherwise never would have been perpetrated.
Excuse me, innocent minds.
That's exactly right.
Are you suggesting here that the defendant had an innocent mind?
No, precisely not. The defense that I sought to present in this case was a defense of so-called sentencing entrapment,
which means the defendant was saying, I had a guilty mind, I was prepared to sell, just not the quantity that I'm charged with selling.
That's exactly correct, Justice Ireland.
And is that the rule you're asking us to adopt here?
Yes, correct. And for exactly the same reason, or virtually the same reason as articulated in Harvard, which is that the state also should not tolerate having its officers instigate serious crime by implanting serious criminal ideas into the minds of otherwise low-level offenders.
I'm trying to figure out how it works. There's sort of like the stepladder of offenses in the drug distribution statute. Right. If the Commonwealth persuades a defendant to sell them drugs, a minimal level, on one day, and on day two ratchet it up to the next level of distribution, and then on day three ratchet it up to the next level, at what point does the entrapment defense apply? Does it apply to the last one, or does it apply to the highest one that was made, or does it make any difference that the Commonwealth was saying the things to urge him to sell drugs at each step along the way? But having made the sale at each step along the way, does he lose the right to raise entrapment as to the lower levels and preserve it only as to the highest level, to the most recent one?
Well, it would depend on at what point there was some evidence of inducement by the government agent, because the defendant even in traditional entrapment defense does have a burden of production in order to even get an entrapment instruction in order to be permitted to argue entrapment. In other words, the defendant has to do some evidence of something more than, as this court has said, mere solicitation.
So if there is evidence of entrapment, let's say at just hypothetically, the third level, and there's no evidence of entrapment at the fourth level, and now we're up at the fifth level, that's the one he's on trial for. Has he waived the entrapment defense as to the third level because there was no evidence as to the fourth?
Well, to be quite honest, that was the factual situation in this case. In other words, there were two sales that were made to the undercover officer. One was a sale of approximately 60 grams of cocaine, which resulted in an indictment for trafficking in over 28 grams. The second sale was the sale for a kilo of cocaine, and that brought about the trafficking in over 200 grams.
Wasn't there first a very small sale of
There would have been, had I been permitted to present the defense of sentencing entrapment.
But I mean, if you look at the entire picture, there were actually three sales.
That's correct.
Going back to Justice Spina's example.
That's correct. And the first sale was a very, very small quantity street-level sale to a separate undercover officer. And Judge Lowy found that there was evidence of inducement preceding the last sale, the sale for the kilo, but not preceding the first charged sale. In other words, the second sale, as Justice Cowan has stated. So in that case, I would suggest that in light of the evidence, in this particular case, in light of the evidence of the first sale for the very small quantity on the street, coupled with evidence there was some evidence of this. It would have been developed further had I been permitted to present this defense of sort of the differences in the level of in the chain of distribution, that there are sort of street-level sellers and there are different people along the chain of distribution in drug distribution operations. And
Isn't this used on the federal level in some part at least because of the importance of the sentencing guidelines there?
Virtually every circuit in the country at this point, and this was not true when this court decided Garcia 11 years ago, has recognized some form of sentencing entrapment as a defense to be presented to the judge at sentencing, and a judge is permitted to impose a lesser sentence.
Yes, but don't they have a very different sentencing scheme than we do?
They do have a different sentencing scheme.
Excuse me, I didn't hear your answer.
They do have a different sentencing scheme. But at least in federal court, there is some forum for a defendant who adduces evidence, at least viewed in a light most favorable to the defendant, supporting a claim of sentencing entrapment, to litigate this claim. And that is at least with the sentencing judge.
Mr. Rudolph, following up on Justice Cowan, here we are dealing with statutory mandatory minimums, correct?
Correct.
So that, in fact, some of the concerns that were expressed, which it's the person on the street who decides essentially what the sentence is going to be, was a concern in the federal courts. Here, presumably the prosecutor, knowing whatever all of the facts are, can decide what it is that the prosecutor, for what crime the prosecutor wishes to indict, correct?
The prosecutor does have that discretion.
So that one of the concerns, at least with respect to the federal courts, that headed off down in this direction. And the second thing is, in Garcia, we specifically suggested, perhaps, that the Mass Sentencing Commission, which had been established, take a look at the subject. Do you know whether or not the Mass Sentencing Commission has taken a look in the 10 years plus since Garcia?
I do. In Garcia, they mentioned that the commission was examining the mandatory minimum sentences that result from the trafficking statutes. I don't know what they did specifically, other than they have not provided sentencing judges any discretion to depart below the mandatory minimum, even in a situation where a judge might find sentencing entrapment, such as this. So that's why we are left with a situation in Massachusetts where a defendant who has such a claim has no forum, neither the jury nor the judge can consider this claim.
Where would entrapment play a role in this case?
In this case, there was in fact an entrapment instruction given, and I argued traditional entrapment to the jury on the two indictments charging conspiracy and charging trafficking in over 200 grams, because there was evidence that at least viewed in a light most favorable to Mr. Saletino, that he effectively reluctantly relented to the repeated requests of the undercover officer to introduce him to other people who actually sold him the kilo of cocaine. He wasn't the actual seller.
The judge gave a pretty good instruction on entrapment. I take it that you wanted something a little bit more. In other words, you wanted the jury to know that he could be sentenced to a much stiffer penalty if they found the 200 grams and he was induced by the police to do it.
I was not asking the judge to tell the jury what the sentence would be. What I wanted the judge to instruct the jury on was that if they had a reasonable doubt about whether or not Mr. Saletino was predisposed to sell over 200 grams, then they could find him guilty of a lesser included offense, whether that is trafficking in over 28 grams or mere distribution, which would have been a question of fact for the jury to decide. That was the request that I made, and in instructing the jury to tell the instruction to the jury clearly said to them, as was pointed out earlier, that the question is whether this was somebody who was sort of possessed of an innocent mind.
Mr. Rudolph, let me just place you on the facts here. The one state that has played around with this is Oklahoma, as you know. And in that case, the situation is a little different. It's the undercover police officer who is doing the sales. And he sells, originally the defendant says, I want X amount, which is a misdemeanor. and the undercover police agent says, why don't I sell you Y amount, which is a felony? In other words, it seemed to me that that was a relatively clear example of where the state affirmatively is attempting to induce somebody who says, I want, as it were, a misdemeanor amount, and there was a history of this defendant having had consuming very small amounts, and it just so happened if you bought, under Oklahoma statutes, if you bought more than the minimum amount, it automatically turned into a trafficking and therefore a felony. Here, it's very hard for me to see. Essentially, it seems to me that what the police were attempting to do was to identify larger drug dealers. In other words, what they were doing was, in essence, using this defendant, not so much to engage in criminal activity of which he might not have been predisposed, but to have him help them identify where's the big stuff coming from. And that seems to me to be less like the classic sentencing entrapment kinds of situations. What is your response to that?
The factual scenario is different in the Leach case, but I think the principle is the same. And the principle is that in either scenario, you can have a situation where it is an agent of the government whose conduct is playing a role in inducing someone who otherwise would not commit that serious an offense into
Here's the
committing that
difficulty.
offense.
This has peculiar meaning in the federal courts on the drug area because the difference between 1 gram and then as you go up, the penalties become very harsh. But if you think of it in any other context, normal law enforcement, with the situation of your client, somebody is on the street corner selling a watch, and turns out not to be a fake, but a Rolex. And the police officer says, look, can you show me where I can get more of these? In other words, the intent is to identify, who is putting this stuff onto the street. It's not drugs.
Well, I agree that there may be one purpose of the law enforcement's conduct may be legitimate, which is to identify somebody higher up in the chain. But in that situation, if the defendant were to say, I'm really not interested in...
Well, no, he said, there's a lot of pressure. I'll help you make, more money. I'll help you make more money. But you've got to, but I want to find out, and it takes them a quantum leap up.
And the rationale underlying entrapment, as it's been recognized in Massachusetts, is twofold. One is a concern with the conduct of law enforcement or other agents of the government, but the other is to hold people responsible, criminally responsible, for their true level of culpability, for what type of crime they really would engage in on their own, without some government officer enticing them, inducing them, pressuring them to commit some more serious crime. So entrapment, there really are two purposes underlying recognizing entrapment, both of which are applicable to the sentencing entrapment scenario. And for those reasons, this Court should today take that step in recognizing sentencing entrapment.
You make this argument about Apprendi. Apprendi doesn't apply here. I mean, the sale of more than 200 grams is an element. I agree with you on that. But that was presented to the jury, and they found him guilty beyond a reasonable doubt of that element.
And my position would be that where an element of the offense is that the government has to prove that the defendant engaged in some discrete act, in as you point out in this case, the distribution of a specific quantity of drugs, then the defendant should be permitted to present the defense to that same jury that, no, I was not predisposed to commit that discrete act. I was predisposed to commit some less serious act. That is a defense that the defendant should be permitted to present to that jury. And the only court in the country that has issued any written decision on whether Apprendi, in fact, now makes this sentencing entrapment a proper defense to present the jury, which we cited in our brief, is the Eastern District of Michigan in the case of U.S. versus Daughtery. And that case, that district court agreed. They said that now that the amount of drugs distributed or possessed with intent is a element of the offense, so should the defendant be permitted to argue to the jury the defendant was not predisposed to engage in that conduct.
How does that implicate Apprendi? I understand what you're saying, that you're being in your view, you're being deprived of a defense. But that's like saying if I can't argue self-defense to the jury, then Apprendi applies. I don't understand why Apprendi applies.
Because in Garcia, this court said, this is a sentencing issue, and if the Sentencing Commission wants to give the sentencing judge some discretion to impose a sentence below the mandatory minimum in light of a sentencing entrapment finding, that's up to the Sentencing Commission. My position is, no, where this is really an element of the offense, the defendant should be allowed to defend in front of that jury on a basis of sentencing entrapment.
But since an entrapment defense is not required by the United States Constitution, the entrapment defense is, in essence, the parameters of it is what this court would say it would be under our law.
That's correct, and I would encourage the court to consider. I mean, this court has already said that under the statutory scheme, that's an element of the offense, and so should it be that that sentencing entrapment is a proper defense. And I would encourage the court to consider whether or not under our Constitution, under Article 12, this should be a defense that a defendant should be permitted to present to a jury.
Thank you, Mr.
Thank you.
Rudolph. Mr. Filos, good morning.
Good morning. Assistant Attorney General Jonathan Offlis for the Commonwealth. May it please the Court. As the Court pointed out, the theory of sentencing entrapment is fundamentally inconsistent with the defense of entrapment as it's applied in Massachusetts. Entrapment...
It's not fundamentally inconsistent. We just decided that we didn't want to go that way, correct?
Well, I think that the defense of entrapment was created to protect innocent minds from being induced.
Well, we're not concerned here with the innocent entrapment defense. What we're concerned about is the sentencing entrapment defense, which all of the federal circuits, although albeit on somewhat different grounds, have recognized. Now, they have a sentencing scheme which is somewhat different, but it seems to me that when you have the legislature saying that there are mandatory minimums, it's not entirely clear to me why one shouldn't look at sentencing entrapment in the same way that the federal courts have looked at it.
Well, I think first we need to look at the way that the circuit courts have looked at sentencing entrapment. I think that the way it's set out, the circuit courts have been kind of inconsistent on how they define it. There's different definitions. Sentencing.
They're almost all in accord except for the 10th Circuit, which seems to be hanging on by its fingernails because of an early decision.
Well, I think some of those courts have talked about sentencing factor manipulation, which is a different beast, I think, than sentencing entrapment. That focuses on the...
There's a more fundamental problem here, in my mind, and that is the evidence doesn't seem to even warrant raising this.
Absolutely not.
I mean, there's not a shred of evidence that this defendant said to the police officer, the undercover police officer, or anybody else, oh, gee, I don't want to sell anything more than what I ever sold to you because, I'm a savvy guy and the penalty goes up. No, all he says is, when he asks for a kilogram, is, well, it's a little tricky, but I think I can get it. They want to meet you and all that kind of stuff.
I think he actually...
So what are we even doing here about this?
I think
dump the whole case on that ground alone.
I think you're absolutely right, and I think it goes a little bit even farther than that. I think the facts show that during the initial buy, the 62 grams, the undercover officer mentioned to the defendant that if things went well, he would like to buy a kilogram. At that point, the defendant said, "Sure, that won't be a problem." Later on down the line, after speaking to whoever his supplier was, there was some evidence that the supplier had a...
I mean, if we approve it in this case, it's going to apply to every drug case.
Absolutely.
Because the facts are so thin here.
Absolutely.
Non-existent, in my opinion.
Absolutely. And that would obviously interfere with what this court has recognized as a legitimate investigative technique of the police, which is, going and starting off slow. I mean, practically speaking, to do these type of investigations, the police can't just go to a drug dealer and say, "Hey, I want to buy a kilogram of cocaine." It's not going to work that way. They have to build up trust. And like the court also pointed pointed out, a lot of times these investigations continue to trace the drugs to the supplier in the bigger fish in this case, in the case. So I think that absolutely that if the court accepts sentencing entrapment under these facts, that it would completely interfere with the way investigations are done. And again, getting back to the point that the facts are completely thin. In fact, the defendant spoke to the undercover investigator on at least 2 occasions that I can remember that he wanted to open up after they went down to the Cape to see his business, that he wanted to go down and open up a point of distribution down the Cape himself. He talked about how it wouldn't be that they imported or they received 10 kilograms of cocaine at a time, and that it wouldn't be a problem in the future for them to, provide whatever the undercover the undercover trooper wanted for an amount. He also, he obviously showed that he had a vast knowledge of the way that these drugs.
So you're suggesting that the judge was wrong to give an entrapment defense of any sort?
No, I think the standard's pretty low for what there just needs to be some inducement above above a simple request, and I think that with the evidence being that the police officer, the trooper, called the defendant on a number of occasions, and affirmatively went out and tried to get him to do this deal, that there was sufficient evidence.
For instruction?
For instruction, but that certainly doesn't mean that there was enough evidence for a jury to find that he was that he was not predisposed.
Mr. Oakley, I have here only the judge's handwritten remarks on the motion, both the defendant's motion for permission to pursue the so-called sentencing entrapment defense and the Commonwealth's motion in limine, not to permit him to do it. And all that the judge says is motion denied to the defendant and motion allowed to the Commonwealth. Is it conceivable that the judge, who's a very experienced judge, looked at this and essentially through the lens that Justice Granier said and said, there are no facts here? In other words, he wasn't saying, I'm not recognizing the defense. There was no evidence. There was no suggestion based on what the defendant had put in front of him.
I can't step into the mind of the judge, but I think that that's a possibility.
Were you trial counsel?
No, I was not.
So is there any transcript of the hearing, or was this just done on the papers? Was there a hearing on these motions?
I believe that there was a hearing, but I don't know. I do believe that the way it was presented to the judge was that the decision in Apprendi versus New Jersey required the court to relook at the decision in Commonwealth versus Garcia because it changed pretty much the law. And I think the judge's ruling was that Apprendi had not affected this court's decision in Commonwealth versus Garcia.
But we don't know that, right? It just says motion denied or motion allowed.
I remember reading somewhere where he said, I can't put my finger where it is, but I do remember reading somewhere where he said that Apprendi did not affect this court's decision in Commonwealth Garcia, which is absolutely the case. The judge's instruction was very, very clear. I think he actually went above and beyond what he actually needed to do. But he specifically laid out the elements of the crimes charged. The jury found beyond a reasonable doubt that the defendant that the amount was over 200 grams, which is the element that I would think that would be under Apprendi. And then he instructed that even if they found all the elements of the crimes, actually the sentencing, the entrapment defense only applied to conspiracy and the over 200 grams. But he also instructed that, once they found the elements of the crime, they had to find beyond a reasonable doubt that the defendant was not entrapped into trafficking in over 200 grams of cocaine. I think that, and he mentioned on a number of occasions that they had to find beyond a reasonable doubt that there was no entrapment. The instruction was very, very clear, and I think it's clear that Apprendi would not apply here. Not to mention the fact that the maximum sentence under all of the crimes charged is 20 years statutorily. So regardless of what the amount was, it would not have raised, Apprendi stands for the fact that any factor that would raise the sentence above the statutory maximum needs to be presented in the indictment, identified in the indictment, presented to the jury, and found beyond a reasonable doubt. There's no fact here that would have raised this above the statutory maximum.
There's a second issue in this case, and that is the judge's refusal to give a missing witness instruction. And as I remember the facts, the informant or the cooperating witness in this case, Mr. Tejada, with respect to the sale of 59 grams or whatever, Mr. Tejada went in with the defendant to a house, the police officer being outside, and then Mr. Tejada came out with the drugs.
That's correct.
And the police officer testified about what he observed of the conversations leading up to that transaction, the fact that Mr. Tejada went in and then came out and gave him the drugs. So Mr. Tejada was the only witness to the actual exchange of the drugs. Is that correct?
That's correct, but the theory of the government's theory in the case was joint venture. Mm-hmm. So under that theory, there was plenty of evidence presented by the trooper to support a joint venture theory for the trafficking.
The argument you make in your brief is that because Tejada really would have just been a corroborative witness, that missing witness instructions don't apply if the witness not called was merely a corroborative witness. You can't really mean that, do you?
I don't think I meant that. I didn't mean to mean that. I didn't mean that. My position was that Mr. Tejada was available to both parties.
But that's not a requirement of the missing witness statute. That whether or not he's available or not, is it? The fact is that
he'd actually been summoned, hadn't he?
Yes, he'd been summoned. He was in court. He was
actually in the courtroom.
He was actually in the courtroom.
So how can he be a missing witness if he's in the courtroom?
That was my position.
But the missing witness has nothing to do with whether the witness is physically missing. It has to do with the Commonwealth's failure to call a witness who one would expect the Commonwealth to call.
Right. And I think that's where the fact that the facts that Mr. Tejada could have testified to, because it was a joint venture theory, were merely corroborative of what the undercover trooper was able to testify.
But isn't one of the foundational elements for getting a missing witness instruction that he'd be more available to one side than the other? And as I recall the cases, and this man was sitting in the courtroom, he could have been called by either side.
That's absolutely correct.
And furthermore, the Commonwealth had a very good reason for not calling him, because he had a massive criminal record.
Right.
And would have been impeached.
Exactly.
Yeah, I have a question on the joint venture issue. Would it be possible that Mr. Tejada could be the other person in the joint venture?
Well, there was evidence. You mean the person who provided the drugs to Mr. Saletino? Is that he was the actual supplier? Is that what you mean?
No, but to have a joint venture, why does it have to be? Well, I mean, you're saying that Mr. Tejada couldn't be the principal.
Well, there was evidence at trial that the defendant, at a later date, when the trooper said that he was concerned about the quality, the defendant said at the later date that the person, Shepe, I think his name was the person who provided the original amount, and that he was providing the second amount, so he didn't need to worry about the quality of the drugs.
But do we really have to worry about that? Because it's plain, is it not, that the drugs were obtained from some third party that was in the house?
Right, and they don't need to...
Because Tejeda went in there with no drugs.
Right, exactly.
Came out
But we
with
don't know
drugs.
Tejeda went in there with no drugs. Isn't that part of the problem here?
Well, I don't know whether, I don't
But
believe...
does it matter? Does it matter who the principal is, as long as there is another person who's the principal?
No, it doesn't matter. You don't need to identify the principal under a joint venture. And like, as I said, there was testimony at trial that the defendant identified somebody else, the other person, who provided the drugs. I mean, therefore, in my mind, that's enough to show that there was another party there that...
Excuse me, what was the defendant testified at trial?
The defendant didn't testify at trial. There was testimony at trial that the defendant had told the trooper when the trooper expressed concerns about the quality of the second purchase, that the person who provided the drugs from the first sale of 62 grams was the same person that was supplying the drugs for the second purchase. Unless there's any more questions, I'll rest on my brief.
Thank you, Mr.
Thank you very much.